Good day everyone, I am Edmund Valenzuela II. And with me is my co-reporter, Mr. Fernandez. We will now begin our discussion on three of the modes of terminating official relations. There are multiple modes of terminating official relations. Three of such modes are naturally caused. First, the expiration of term or tenure of office. Second, by reaching the age limit or retirement. And lastly, is by the death or permanent disability of a public officer. Let us begin first with the expiration of term or tenure of office, which will be discussed by my co-reporter, Mr. Fernandez.
Good day everyone. My name is Clement Moises Fernandez. I will be discussing one of the modes of terminating an official relationship, which is the expiration of term or tenure. But we need first to distinguish the difference between term and tenure. In the case of Tapacia Nueno versus Angeles, the Supreme Court defines term as the time during which the officer may claim to hold office as of right, and fixes the interval after which the several incumbents shall succeed one another. The tenure represents the term during which the incumbent actually holds the office. The term of office is not affected by the holdover. The tenure may be shorter than the term for reasons within or beyond the power of the incumbent. Here are some of jurisprudence laid down by the court discussing expiration of term or tenure. In the case of Astrachia versus Bangladesh, the court ruled that when a public officer holds office at the pleasure of the appointing authority, his being replaced shall be regarded as termination through expiration of term, not removal. In Osmeña versus Comelec, where the Constitution provides that the term of office of local elected official is 3 years, Congress cannot, by a law calling for delayed elections, effectively reduce the term. In Ortiz versus Comelec, upon the change of government brought about by EDSA revolution, the acceptance by the president of a courtesy resignation, the constitutional officers with fixed terms of office resulted in the expiration of term, entitling the officers to retirement benefits. The Supreme Court highlighted that a courtesy resignation cannot properly be interpreted as resignation in the legal sense, for it is not necessarily a reflection of a public official's intention to surrender his position. Rather, it manifests his submission to the will of the political authority and the appointing power. In the case of Gloria versus Judge de Guzman, the court emphasized that here, there was no termination in the sense that termination presupposes an overt act committed by a superior officer. What happened was that the private respondents' appointments or employment simply expired, either by their own terms, or because they may not exceed 1 year, but most importantly, because PASCA was dissolved and replaced by PSCA. Here are some of the rules governing commencement and expiration of term of office. First, where the statute fixes a period within which a chosen officer may arrange his affairs and qualify for the office in a prescribed manner, officer's term begins upon qualification. Second, where no time is fixed by law for the commencement of his official term, term begins from the date of appointment in cases of an appointed office, or from the date of election, in case of an elective office. Third, where the law fixing the term of a public office is ambiguous, the one that fixes the term of the shortest period should be followed. Fourth, where both the duration of the term of office and the time of its commencement or termination are fixed by constitutional or statutory provisions, a person elected or appointed to fill the vacancy in such office shall hold the same only for the unexpired portion of the term. Fifth, where only the duration of the term is fixed, but no time is established for the beginning or end of the term, the person selected to fill the vacancy in such office may serve the full term and not merely the unexpired balance of the prior incumbent's term. Sixth, where only the duration of the term is fixed, but no time is established for the beginning or end of the term, the person selected to fill the vacancy in such office may serve the full term and not merely the unexpired balance of the prior incumbent's term. One of the important principles that we need to understand, which is related to the expiration of term, is the principle of holdover. Under this principle, the public officer is entitled to hold his office until his successor shall have been duly chosen and shall have qualified, in the absence of any express or implied constitutional or statutory provision to the contrary. The purpose of the holdover principle is to prevent a hiatus in public service. One of the most important cases that we need to remember is Lecaros versus Sandiganbayan. Here, the Supreme Court ruled that although the 251 does not authorize a Sangguniang Kabataan chairman who sits as a Sangguniang Bayan member to continue to occupy his post after the expiration of his term in case his successor fails to qualify, it does not also say that he is proscribed from holding office. Absent an express or implied constitutional or statutory provision to the contrary, an officer is entitled to stay in office until his successor is appointed or chosen and has qualified. The legislative intent of not allowing holdover must be clearly expressed or at least implied in the legislative enactment, otherwise it is reasonable to assume that the law-making body favors the same. Here are some important rules to take note related to principle and holdover. During this period of holdover, the public officer is a de jure officer. When the law fixes a specific date for the end of the term, there is an implied prohibition against holdover. However, it is important to take note that any public officer who shall continue to exercise the duties and powers of his office beyond the period provided by law shall be punished under Article 237 of the Revised Penal Code. This ends the presentation. I hope that what you have learned in this video lecture will help you a lot in your studies. Thank you and have a great day. Take care, future lawyers.
Now, let us proceed with the second topic. The reaching of the age limit by the public officer. In reaching a certain age, a public officer may be compulsorily made to retire. Most public officers in the government are forced to retire upon reaching the age of 65. However, in the judiciary, the compulsory retirement age is 70 years old. Also, there are cases where this compulsory age retirement does not apply and termination of official relations may be made early or even extended. These are the cases of optional retirement. Some special laws, such as Republic Act 1616, which is an mandatory law for the GSIS Charter, allows optional retirement regardless of the fact that the officer has yet to reach the compulsory retirement age. Provided, however, that such an officer has rendered a minimum number of years of government service. But there are also instances where services of public officers are extended, even if they have reached the compulsory retirement age. Civil Service Memorandum Circular Number 27 allows extension of service only for a period of 6 months and may be extended up to a year. This would be in conflict with Section 11 of PD 1146, which allows extension of service for the purpose of completing the 15 years of service required to avail of retirement benefits. In the case of Sena vs. CSC, the court disallowed a similar administrative issuance which limits the extension only for a year. The court upheld that the administrative body cannot make issuance that would be contrary to law, that is Section 11 of PD 1146. Thus, the court allowed an extension of service even beyond the 65 years compulsory age for the purpose of completing the 15 years to avail of retirement benefits. This ruling, however, was modified in the later case of Rabor vs. CSC. The court, in this case, emphasized that the ruling of Sena would ultimately render the compulsory retirement age of 65 useless. The court exemplified that a public officer may be appointed at the age of 64, avail of extensions, and work up to the age of 79. Thus, CSCMC 27 is upheld and is to be construed with Section 11 of PD 1146, allowing only an extension of 1 year to complete the 15 years requirement. Further, in the judiciary, the court also allows extension of service if it is satisfied that the career of the retiree was marked by competence, integrity, and dedication to public service. A retiring officer, after termination of official relations, would be awarded with the retirement benefits due to him or her. Such benefits, however, are also subject to conditions such as limitation of re-employment, exclusivity of benefits, and also other conditions to be satisfied for entitlement. The last natural cause of termination of official relations is death or permanent disability. This is because such occurrence would necessarily render the office vacant and the official relation terminated. Further, such vacancy would also be subject to the rules provided under the Constitution or the laws governing such vacancy. In the case of Gaminde vs. Commission on Audit. For the Commission on Audit, it was held that in order to preserve the periodic succession mandated by the Constitution, the rotational plan requires 2 conditions. First, the terms of first commissioners should start on a common date. And second, any vacancy due to death, resignation or disability before the expiration of the term should be filled only for the unexpired balance of the term. To give a more clear picture of rules that would govern upon the death or permanent disability of a public officer, let us see the rules on succession for the President. First, in case of death or permanent disability of the President-elect, The Vice President-elect shall become the President. Second, in case of death, or permanent disability, or removal from office, or resignation of both the President and Vice President, the Senate President shall then become the President. Third, in case of inability of the Senate President, then the Speaker of the House of Representatives shall act as President, until a President or Vice President shall be elected and qualified. And this concludes our discussion on the natural causes of termination of official relations.